having any business before this honorable court, now draw nigh. Give your attendance, you shall be heard. God save the Queen.
Please be seated. Admission of lawyers. Tabassum R. Floyd.
May it please the court, I move that my sister Tabassum Arthur be admitted as a lawyer of this honourable court.
That Tabassum Arthur be admitted as a lawyer of this court.
Luke Thomas Chapman.
May it please the court, I move that Luke Thomas Chapman be admitted as a lawyer of this honourable court.
That Luke Thomas Chapman be admitted as a lawyer of this court.
Yi Wen Chen.
May it please the court, I move my daughter, Yi Wen Chen, to be admitted as a lawyer of this honourable court.
That Yi Wen Chen be admitted as a lawyer of this court.
Taya Elizabeth Cleary.
May it please the court, I move that Taya Elizabeth Cleary be admitted as a lawyer of this honourable court.
Let Taya Elizabeth Cleary be admitted as a lawyer of this court.
Farah Saba Ganawi.
May I please the court, I move that my friend Farah Sabaganawi be admitted as a lawyer of this honourable court.
Let Farah Sabaganawi be admitted as a lawyer of this court.
Margaret Hannah.
May it please the court, I move that my sister Margaret Hannah be admitted as a lawyer of this honourable court.
Let Margaret Hannah be admitted as a lawyer of this court.
Richard Harvey Keir.
May it please the court, I move that my brother Richard Harvey Keir be admitted as a lawyer of this honourable court.
Let Richard Harvey Keir be admitted as a lawyer of this court.
Ekna Samali De Silva Marinage.
May it please the court, I move that Ekna De Silva Marinagi be admitted as a lawyer of this honourable court.
That Ekna Sonali de Silva Marinagi be admitted as a lawyer of this court.
Marissa Kate Norris.
May it please the court, I move that my friend Marissa Kate Norris be admitted as a lawyer of this honourable court.
Let Marissa Kate Norris be admitted as a lawyer of this court.
Natalia Petikova.
May it please the court, I move that Natalia Petikova be admitted as a lawyer of this honourable court.
Let Natalia Petikova be admitted as a lawyer of this court.
Roy Wang.
May it please the court, I move that Roy Wang be admitted as a lawyer of this honourable court.
Let Roy Wang be admitted as a lawyer of this court.
Genevieve Rachel Westbury.
May it please the court, I move that my daughter, Genevieve Rachel Westbury, be admitted as a lawyer of this honourable court.
Let Genevieve Rachel Westbury be admitted as a lawyer of this court.
Andrew David White.
May it please the court, I move that Andrew David White be admitted as a lawyer of this honourable court.
Let Andrew David White be admitted as a lawyer of this court.
Vincent Yin.
May it please the court, I move that Vincent Yin be admitted as a lawyer of this honourable court.
Let Vincent Yin be admitted as a lawyer of this court.
Reshma Elsa Zachariah.
May it please the court, I move that Reshma Elsa Zachariah be admitted as a lawyer of this honourable court.
Let Reshma Elsa Zachariah be admitted as a lawyer of this court.
Hao Zhao.
May it please the court, I move that Hao Zhao be admitted as a lawyer of this honourable court.
Let Hao Zhao be admitted as a lawyer of this court. It will be necessary for the purpose of an oath that all those being admitted today, please stand up but remain in your current places. Please stand.
Tabassum Arthur. Luke Thomas Chapman. Yi Wen Chen. Taya Elizabeth Cleary. Farah Saba Ganawi. Margaret Hannah. Richard Harvey Keir. Ekna Sonali De Silva Marinage. Marissa Kate Norris. Natalia Petikova. Roy Wang. Genevieve Rachel Westbury. Andrew David White. Vincent Yin. Reshma Elsa Zachariah. Hao Zhao. Do you solemnly swear or declare and affirm that you will truly and honestly conduct yourselves in the practice of a lawyer of the Supreme Court of New South Wales, and that you will faithfully serve as such in the administration of the laws and usages of this state according to the best of your knowledge, skill and ability. Would you please say, so help me God, or I do?
I do.
Would you please be seated?
Now that the formal part of the proceedings has ended, I'd like to warmly welcome you to the Supreme Court of New South Wales. Present with me on the bench today is Justice Gleeson to my right, who is a member of the Court of Appeal, and Justice Hamill to my left, who is the Judge of the Common Law Division. Together, we constitute the court that has, in exercise of its jurisdiction, admitted you to practice. As we gather here today, I would like to begin by acknowledging the traditional custodians of the land on which we meet, the Gadigal people of the Eora Nation, and pay my respects to their elders, past, present and emerging. We recognise the long-standing and enduring customs and traditions of Australia's First Nations and acknowledge with deep regret the role our legal system has had in perpetrating many injustices against Aboriginal and Torres Strait Islander people. To all the new lawyers here today, welcome to the legal profession. Today is a day for celebration. You've all worked extremely hard to get here through caffeine-fuelled nights, trying to solve obscure problem questions, reading countless wafer-thin pages of textbook, and more cases that you can hope to remember. I can assure you you'll forget all of them very quickly, and it won't really matter very much. You have entered the world of eggshell skulls, encountered a mysterious, reasonable person, and have understood that the Constitution consists of so much more than just the vibe of the thing. In becoming a lawyer, you have today joined a century-old profession with ancient origins. The custom of advocates swearing an admission oath dates back to the 12th century. This court first admitted lawyers to practice in 1824, at which stage the Supreme Court was only just in the stages of construction, and by 1830, the names of lawyers were entered onto the rolls in this state. You have now become part of this tradition, almost 200 years later. Perhaps, for some of you or your family and friends, that is how long it feels like you've been studying. On that note, I'm pleased to welcome those with you today or watching on live stream. For many of you, the support of your family and friends would have been invaluable. No doubt, they've also often been on the receiving end of your finely polished skills of argument and persuasion. I do hope you take the time to thank them today. The oath or affirmation you have made today is a serious one and deserves solemn regard. Whether you work in private practice, at the bar, in a community legal centre, or in an entirely different field, you should be known for your honesty, your integrity, and your commitment to justice. It is an acknowledgement of this weighty responsibility that we observe today's unique formalities, including the moving of lawyers, swearing of oaths, and even our somewhat unusual choice of fashion. On that note, I recall some years ago, a young member of the audience asked if we were doing Santa photos after the ceremony. Regrettably, I had to disappoint him. However, although we mark this occasion with formality and tradition, not everything in the legal profession remains unchanging. You'll be unsurprised to hear that last year we had to adapt quite a bit. COVID-19 meant a rapid shift to increased use of virtual courtroom setups and technology to ensure that access to justice continued in the midst of a pandemic. Things didn't always go smoothly, as those with me on the bench can certainly attest to. There have been real difficulties to grapple with in terms of open justice, effective communication, and fairness to participants. And occasionally, a lawyer might even get stuck behind a Zoom kitten filter. But for all the challenges we faced, the impetus is greater than ever before for us to prioritise flexibility and accessibility. Better use of technology and increased working from home arrangements have profound implications for how our legal system interacts with many people, including those in rural and remote areas, those with a disability, medical conditions, or carers' responsibilities. As the newest members of the profession, you are at the forefront of innovation in the law and have a unique opportunity to see through changes so justice is done openly and equitably. There are, of course, other changes that deserve attention. When we think of the diversity of the legal profession, we encounter the duality that we have come very far and that much still needs to be done. Though women were originally not permitted to practice, since 2018, women have made up more than half of the solicitors with a practising certificate in New South Wales and currently make up 63% of solicitors under the age of 30. Women occupy many of the most senior positions in the law, including, of course, the Chief Justice of Australia. However, women can continue to face challenges of representation, including amongst judges of this court and amongst barristers, particularly in speaking roles before the High Court. It is heartening to see that the local court of New South Wales has almost achieved gender parity amongst magistrates, but we must not be complacent about these matters. There are other noticeable diversity concerns that we must face head on. Aboriginal and Torres Strait Islander peoples and people from diverse cultural backgrounds continue to be alarmingly unrepresented in the legal profession, and particularly within the judiciary and the ranks of senior counsel. We must also be alert to barriers to the profession for people from less privileged backgrounds. Law should not be a profession for the wealthy, and the idea that students may be dissuaded from studying law by the cost of a law degree, which this year has again increased, or because of other systemic issues, is troubling. Not just this, but we will only achieve a truly diverse profession when barriers to advancement are broken down and people from different backgrounds are properly supported in a collegiate and inclusive environment free from harassment and discrimination. Those issues are fundamental to a just and transparent legal system and thus to the legitimacy of the rule of law. We need diverse representation amongst advocates and judges so that all people who become involved in our legal system can be properly heard and fairly engaged with by a system reflective of our broader community. Despite these challenges, there is real scope for change. There is far greater diversity of background amongst junior lawyers than those who have been around for as long as me. You only need to look around the courtroom at the new admittees and then to the pictures on the wall to see that this is so. You are in a unique position as new lawyers who are entering the profession at a time when more than ever your words and actions are having an impact for good. You are being heard and taken seriously when you agitate to correct injustices, whether it be speaking out about unsustainable working conditions, sexual harassment within the profession or bullying within the profession, unfair laws or systemic failings affecting our society's most vulnerable. I urge you to continue to speak up for these things. They do matter. You are the future of the profession and will steer the direction it will take. As a lawyer, you will also need to make difficult ethical decisions from time to time. With regard to our personal characteristics, lawyers have been the butt of jokes for centuries. Cynics would say there are only a handful of lawyer jokes, the rest are true stories. But jokes aside, you must use the tools you have developed to think critically and not compromise on your fundamental duties to the court and the administration of justice and other ethical duties you must uphold. Now that you are lawyers, you can get paid to argue instead of just arguing for free. Of course, there is a lot more to it than that. You're an advisor, a problem solver, a mediator, and an advocate for the marginalised. As you go about your day-to-day work, remember that you're not merely dealing with the law in a vacuum or as a series of abstract concepts, but dealing with it as it applies to people's lives. For this reason, you must strive to deliver legal services competently and fearlessly with courtesy and integrity. Justice Gageler, before he was a High Court judge, once said, "You must be prepared to give the same answer to the same questions for the same reasons, no matter who asks the question or for what purpose or in what context the asking may occur." This is foundational in upholding the rule of law. For those of you who will practice law, the way you communicate information to others will have profound consequences for access to justice. For a non-lawyer, law is often incomprehensible. One of your roles as a lawyer will be to make law accessible to others, sometimes by deciphering legal complexities, other times by deciphering poor legal drafting, and sometimes both. One thing you will regrettably strike throughout your career is legislation which seems carefully crafted with the object of ensuring that no one can understand it. Your task is not just to understand it, but to explain it clearly to those whose rights and interests are affected by it. As lawyers, we must not keep law locked up as something knowable only to us. A client reading your advice should be empowered to understand your meaning, not mystified and confused. So be clear and concise in your writing and your speaking. Plain English is powerful. Consider, do I really need to say aforementioned or herewith? Must I sprinkle in that Latin phrase? Should I really use double negatives, tautologies, split infinitives and wordy clauses that take up a whole page? I would suggest the answer to that question is plainly no. The best advocates can make their point simply and succinctly. Some of the most experienced lawyers and judges regrettably could also use that reminder. Don't pick up bad habits from those of us who are old and crusty. I also want to speak about failure. I would not be surprised if there are quite a few overachievers and perfectionists in the room today. Even so, at various points of your career, you will make mistakes, some minor, some more serious. When you do make mistakes, your commitment to honesty, integrity, and the administration of justice means that you must take responsibility, correct what you can, and learn from those errors. You must fail at times in order to grow. What is important is that you try not to make the same mistake twice. Even as Chief Justice, my decisions have on occasions been successfully appealed to the High Court. At those times, I'm always obliged to tell myself that the High Court is never wrong. But in fact, at times, even dissenting High Court judgments become the law. Finally, I want to emphasise that your mental health is extremely important. This may sound unexpected at this type of ceremony, but the law is not everything. There may be times when you feel overwhelmed, burnt out or distressed. If you do, you should not be afraid to seek professional help or take a step back when you need to. Also remember that the law is a collegiate profession, and in times of difficulty, the support of your peers will prove invaluable. Let me give you one example. Although you might find it hard to believe, I was admitted quite a long time ago. I lost my first case, and I lost many more after that, probably more than I won. Throughout my 35 years in practice, I could always count upon the other barristers on my floor to share my disappointment at the unfairness of the verdict, the sly tactics of opposing counsel, and most often, I regret to say, the obtuseness of the judge or judges before whom I was appearing. I hasten to add that I do not include either of my fellow judges on the bench in that comment. On behalf of all the judges of the Supreme Court, particularly on those sitting here today, I once again congratulate you on your admission and welcome you to the legal profession. The court is now adjourned.
All stand.